In 1955, there were about 560,000 people in state psychiatric hospitals throughout the United States. Today, there are fewer than 50,000. Adjusting for growth in population, had the commitments to state hospitals held in 1955, there would now be more than 900,000 persons in state hospitals. Then something happened to change that. In 1972, the U.S. Supreme Court decided the case of Jackson versus Indiana. That case effectively shut down mental hospitals and insane asylums across the country. As a result, there are today some 450,000 homeless people in the United States. About a third of these are mentally ill. In addition, roughly 16% of prisoners held in jail are mentally ill. So the situation of the homeless and the incarcerated as it exists today was the unintended consequence of the ruling in Jackson. This dilemma facing the country has given rise to strong opinions that we are mistreating our mentally ill. A friend in New York City once told me that he came across the mentally ill every day. He stepped over them in the streets, looked the other way as they rummaged through trash bins in some alley, and paid no attention to their ravings. A critic once complained that although on street corners all over the United States, very sick people are left to rot, the federal government ignored the problem by not addressing it in a written report issued by the President's Commission on Mental Health. He contended that most of the mentally ill roaming the streets are too sick to know they are sick, and claimed that roughly 50% of schizophrenics and those with bipolar disorder don't know that they are mentally ill. If treatment is left as an entirely voluntary choice, he stated, it is as it has been in the past, these people will choose continued illness and misery. His solution was to fund and build facilities where such individuals can be treated involuntarily. Whether the mentally ill roaming the streets should be treated involuntarily is today a heavily debated issue. The ACLU, for example, maintains that there exists a right to be untreated, an untreated schizophrenic. No matter where one stands on the question, one glaring fact exists in communities all over the country. Until reforms in the law take place in your jurisdiction, it will be necessary for you, as peace officers, to cope with this difficult issue. You can do so more effectively if you become trained in dealing with the mentally ill that you'll come in contact with in your work. My comments are offered to help you understand the law as it applies to them. I first suggest that you familiarize yourself with the laws in your jurisdiction on mentally ill persons, not only as criminal defendants, but in civil proceedings seeking commitment. In my own jurisdiction, for instance, we have the Mental Health and Developmental Disabilities Code, which applies to mentally ill adults, and the Children's Mental Health and Developmental Disabilities Act, which of course applies to juveniles. There is also Article 9, entitled Mental Illness and Competency, of our jurisdiction's statutory chapter on criminal procedure, which sets out the procedures for dealing with the issue of competency, whether at time of commission of the crime, at time of trial, or at sentencing. Section 10 of our code deals with emergency mental health evaluation and care, under which a police officer is authorized to detain and transport a person for emergency mental health evaluation and care in the absence of a valid court order under certain situations. One of these is if the officer, based on his own observation and investigation, has reasonable grounds to believe that the person, as a result of a mental disorder, presents a likelihood of serious harm to himself or others, and that immediate detention is necessary to prevent such harm. The Act pertaining to children or juveniles has similar provisions. Your jurisdiction has laws that serve the same purpose, and you should read up on their requirements. The important point I want to stress here is that there are alternatives available to you other than putting someone you believe has broken the law in jail. Jails are usually ill-equipped, if at all, to treat the mentally ill. It's up to you to assess whether any of these statutory provisions apply and to handle the person you're dealing with accordingly. Law enforcement officers should also be aware of available facilities and services at the local level. Community mental health services, children's psychiatric facilities, state hospitals for the mentally ill, adolescent treatment facilities or services. Concerning children, you should review the requirements outlining a peace officer's responsibilities involving emergency mental health evaluation and care of children, such as the provisions under the Children's Mental Health and Developmental Disabilities Act in my own jurisdiction. Our federal Constitution and all state constitutions afford certain rights to our citizens, including due process, equal protection, assistance of counsel, and the right to a fair trial. These rights are premised on fairness and civility. Because a mentally ill person has all of these rights, his illness must be taken into account throughout the judicial process to assure these rights are protected, including the giving of special considerations and competency determinations. If our laws provide these rights and allow special considerations for the mentally ill, why should the same sense of fairness and human decency not apply to assure that these protections are accorded to them from the beginning of a case, the moment a police officer first makes contact with him? For that to happen, police officers owe it to themselves, to the public, and to their employer to know generally the symptoms of mental illness. They shouldn't hesitate asking questions of the individuals they come in contact with, their families, or their friends, to determine if special treatment is necessary. Essentially, a police officer should perform a balancing test. On the one hand, he should assess the situation with the aim of protecting himself from danger, while on the other hand, preserving and respecting the rights of the individual encountered in any given situation. I believe that if an officer trains himself for encounters with a schizophrenic or a person suffering from bipolar disorder, he'll be better equipped to lessen the dangers to himself, to the mentally ill person, and to others. I say this because the dilemma of the mentally ill has given rise to many unfortunate incidences. I'd like to mention a couple. Some of you may be aware of other cases in your own state. One of the cases occurred in Seattle, Washington. A friend of who lives there told me of an incident in which a policeman was dispatched to a neighborhood where a naked man was seen running in the streets, ranting and raving. The officer confronted him, shouts were exchanged, and the officer began struggling with the man. In that struggle, the man got hold of the officer's weapon and shot him dead. The officer had a wife and 2 children. Another case occurred in Albuquerque, New Mexico, in July of 2003. And I'll spend more time on it to emphasize the problem. In that case, an Albuquerque policewoman tried to arrest a mentally ill man. In the struggle that ensued, the man threw the officer to the ground, took her gun, and shot her. He then walked down the street, wildly firing the pistol over his shoulder until police, later arriving at the scene, were forced to shoot and kill him. In the aftermath, the local press revealed the man's mental illness and his extensive arrest record for non-dangerous property crimes. The public rightly asked, how can this be? How can someone mentally disturbed like this man be arrested time and time again, only to be released back on the street by a judge? Some asked bitterly, is the county jail merely a hotel that a mentally ill person can check into and out of at will? The chief judge of the county's district court, to make the public aware of the problem faced by the mentally ill in the courts, wrote a column in a daily newspaper. He answered the question I just posed about whether the county jail was merely a hotel by stating, as shocking as it may be to the general public, the answer is yes. He then went on to explain the unfortunate history of the mentally ill man. The judge complained that under present state law, a judge was extremely limited in what he could do with an incompetent person who had broken the law, but had not done so in a dangerous way. He suggested a solution. The legislature, he said, should change the law to allow judges the ability to send incompetent offenders into a mental health system that is set up to help them. This idea isn't new. Other states have incorporated these changes into its laws, as New York has done. Under the new law, New York saw an 86% reduction in incarcerations and an 83% reduction in arrests of the mentally ill. Dr. E. Fuller Torrey, who presently works on the problem, has pointed out people who are rendered incompetent by severe mental illness need treatment based on need, not dangerousness. As I understand Dr. Torrey, what he means is that society shouldn't wait until the mentally ill person becomes dangerous, endangering his own life or the lives of police officers or others. Instead, these individuals should receive treatment for their illness long before that danger exists, as occurred in the two cases I just noted. These cases also serve to stress another important point. Police officers should be aware of the potential dangers to themselves when coming in contact with a mentally ill person. Both the situation and the person must be handled differently from the usual case.